There he is. I didn't know if I was going to have to update your technology because I know my skills, Mr. Cohen, are lousy. So you are far ahead of me. I can see you now. Okay, Mr. Garfield, my understanding is you are here on behalf of the appellant. Did you wish to reserve time for rebuttal?
3 minutes, Your Honor.
So noted, counsel, and I will do my best to let you know when you get to 17. You
Thank
may
you.
proceed.
All right. Good morning. May it please the court. My name is Neil Garfield, and I represent the appellant Ann Marquis Kiliani. Thank you for granting oral argument. The primary focus of this appeal is judicial process and jurisdiction. Appellant had good grounds to challenge the judgment and the bid and sale, including a legitimate challenge to the assignment of the credit bid. All such grounds relate back to the question of jurisdiction. The lower court had an obligation to conduct an evidentiary hearing on the issues raised by the judgment holder and the subsequent bidder. Since the assignment of bid recited no consideration, it was evidence. If it was evidence, then it carried a presumption that no consideration was paid, a question that could have been addressed by opposing counsel in an evidentiary hearing. The jurisdictional significance is that if no consideration was paid, then none was due by inference or even presumption. Let's be clear about one thing. From the beginning of this case, the appellant, appearing pro se, consistently tested, challenged jurisdiction on the basis of the identification and standing of the claimant, the named plaintiff. And the record shows that between the filing of the complaint, the assignment of the bid, the certificate of sale, and other documents, it keeps flipping back and forth between Deutsche Bank National Trust Company as trustee for a trust and Deutsche Bank National Trust Company on behalf of registered certificate holders. So the first question is, what does that mean on behalf of registered certificate holders? And we have no clue from the record. The assignment of bid and the sale was to Deutsche Bank National Trust Company on behalf of the certificate holders. But the assignment of bid was filed by an attorney, unsworn, and recited no consideration. One of the things that is raised here, again, something that could have been resolved by an evidentiary hearing, is that an unsworn statement from an attorney is not evidence of anything. In fact, it raises the presumption of no consideration. That's why I cited Schaefer versus Cedar in the fourth DCA. While normally these kind of events may not relate back to the issue of jurisdiction, it does in this case. In the foreclosure lawsuit, the only place where any name appears is in the style of the case and one exhibit. In the body of the complaint, the claimant is not identified as to who or what is suing. Kiliani fought, pro se, lost on the issues raised by that omission and some other clearly defined deficiencies or even alleged fabrications. She lost, admittedly, and lost over and over again in repeated attempts. The the Alamanza deposition came up after judgment, and in that the man who supposedly signed the endorsement of the note said, I didn't sign the note. And the forensic report clearly suggested that the endorsement of the note was fabricated. Now, Kiliani returns with a challenge to jurisdiction based on the assignment of bid, the sale, and the jurisdiction over the subject matter. This is caused by the execution of an assignment of the credit bid belonging to the judgment holder, allegedly from the claimant, Deutsche Bank National Trust Company, for the trust, which was described in the style of the case, to a group of new parties who apparently have no notice of these proceedings. They're like being drafted in. It is executed by an associate attorney of the law firm pursuing foreclosure and does not recite consideration. The new parties are described but not named.
Mr. Garfield, may I ask you a question?
Yes.
What difference does that make? The supposed lack of consideration, isn't that a matter between the assignor and the assignee? I mean, by this time, the foreclosure judgment has been entered against your client back in whatever it was, 2018 or 2019.
Perfect question, Your Honor. The answer lies in what appears to be a novel issue of law. The question that your question raises is whether an assignment of bid should be treated under the law the same as an assignment of the mortgage. And our argument is that it should be treated that way. An assignment of mortgage without consideration is a legal nullity. The judgment was based upon a presumed valid assignment of the mortgage and the underlying obligation. If a party is allowed to assign that bid without consideration, then it opens the door for remote parties to initiate litigation, not submit themselves to the court jurisdiction, not present their interest to the court, if any, and then take the benefits of a foreclosure judgment for which they did not have any right to bring. You're entirely correct, I think, in identifying that issue. What does this assignment of bid mean, and what difference does it make? That's the question we're bringing up. If our view of it is adopted, then the assignment of bid raises question as to why was consideration not recited, and if so, was consideration paid, and if it was not, was there none due, and that goes back to whether or not there was a claim at all. But if you accept opposing counsel's view, then the assignment of bid makes no difference. And the ability to bid the property in without payment and then the subsequent sales goes to, in this case, unidentified parties who are not subject to the jurisdiction of the court. I think it does make a difference And in this world of complexity that all starts with an attorney saying this is a standard foreclosure, um, I think it is incumbent on the courts to be just as careful in their scrutiny of the claim and the claimant as they used to be back when I started practice a long time ago, um, where the parties and the paperwork had to be in order before any judgment could be entered. I myself, at times representing banks and so forth, where I didn't have my file in order, was sent home without opposition. The assignment of bid raises that question. And if the assignment of bid is considered by this court to be not subject to the same rules as an assignment of mortgage, then the result opens a moral hazard door which is already being exploited. In this case, all we're asking for is a hearing on the subject of why this happened, and a hearing on whether or not it affects jurisdiction. I think that hearing should have occurred and that the lower court erred in not granting the hearing, even though it was asked for. But even without that, with the jurisdictional questions on the table, I think the court was obligated to order a hearing on it. Did I answer your question? If we're right, then the assignment may have been void, or perhaps it wasn't evidence, or maybe it's an unsworn statement that should not even be taken into consideration. But if that's the case, then the deed issued to the registered holders of certificates, whoever they are, may be facially invalid as well. And Kiliani has been challenging throughout and now the complaint, the judgment, the bid, the certificate of sale to the registered owners, and the sale. Opposing counsel seems to be implying, I think, that a loan account receivable was held by those unidentified owners of unidentified certificates as they may appear on an unidentified registry, none of which was mentioned in any pleading or exhibit. Appellant asserts that the failure of the lower court to allow inquiry into the introduction of new parties was fundamental error. This brings in the Schlashy case, I have trouble pronouncing it, that this court rendered, in which there was a successful bidder, and title was supposedly in the name of that successful bidder, and that's what we have here, but they're not identified. I think many of the facts in the Schlishy case are very similar to this, and that could be used as a guide. So the thing that I want to highlight here is that Complaint was filed by Deutsche Bank National Trust Company as trustee for a trust. Body of the complaint does not identify the trust or even Deutsche Bank National Trust Company. The assignment of bid, which occurs a couple of years later, was to the certificate holders. The notice of foreclosure was back to Deutsche Bank as trustee for the trust. The certificate of sale went back to the certificate holders. The certificate of title went to the certificate holders. So we have this flip-flop back and forth. I think that's enough on its own to raise questions about whether or not the right party was making a claim or if either party had a claim. There are obvious jurisdictional questions arising from the trial court's acceptance of the style as though it was an allegation in the body of the complaint. But we concede that a lot of those issues are litigated and that Kiliani does not have the right to contest things that were litigated to conclusion. But on the issue of whether or not the lower court had authority to rule, that issue continues, and it cannot be conferred by an erroneous decision or res judicata or collateral estoppel or any of those doctrines that might otherwise apply. The introduction of registered holders of certificates, assuming the assignment of bid matters, as Judge LaRose pointed out, is the introduction of a legal person or entity or group of people. And the related issue is whether the introduction of such language in an assignment of the credit bid has any effect on the ability of the named assignee to buy the property at auction without cash. That assignment, if it was going to be executed at all, should have been executed by an officer of Deutsche Bank. It was not. So, a mystery.
Counsel, I need to perform my obligation until you're at 17.
I'm at 17. That gives me my 3 minutes for rebuttal.
That is correct, counsel.
All right, then I will shut up. Thank you.
Okay. So duly noted.
May it please
Okay.
the court.
Let me stop the and clear the time so counsel doesn't start at 17. Okay. Mr. Cohn, you may begin.
Thank you, and may it please the court. My name is Joseph Cohn. I represent the appellee, Deutsche Bank National Trust Company, as trustee for the trust. This is an appeal from an order denying a motion to vacate a final judgment of foreclosure entered in 2016. And yet the appellant, Ms. Marquise, does not identify any basis under Rule 1.540B to vacate the judgment. In fact, neither of the two appellate briefs even mention or cite to Rule 1.540 once. And ultimately, this most recent motion to vacate, just like the many prior motions to vacate, fails to provide a basis for finding that the final judgment is void or that it was the result of any extrinsic fraud, which would be the only two grounds to vacate it at this late stage. And instead, it's clear that Ms. Marquise is just attempting to relitigate her affirmative defenses of lack of standing, lack of capacity to sue, and then attaching these conclusory labels of void and lack of jurisdiction to those defenses. And as Mr. Garfield said, these defenses have been litigated ad nauseum for many years. And so ultimately, they don't provide a basis for vacating a judgment under Rule 1.540B. She's failed to establish that the trial court abused its discretion in denying her serial motion to vacate, and therefore we'd ask the judgment that the order be affirmed. This case has a very lengthy procedural history. I won't go through all of it, but I do think it is really the beginning and end of the analysis here. This is a 2013 foreclosure case that resulted in a final judgment in 2016 following a contested trial. Standing was the main issue at trial, and the trust proved its standing based on its possession of the original note endorsed in blank. Ownership has never been relevant. Assignments of mortgage have never been relevant. There's never been any issue as to ownership or any of those issues. It's just that the trust possessed the original note and therefore was entitled to foreclose. It was endorsed in blank by the original lender. This court affirmed the final judgment in 2018, case 2D 165327, after extensive oral argument, extensive briefing. Ms. Marquise even moved for rehearing en banc, or certification, and this court denied that motion. She's also engaged in extensive post-judgment challenges with the trial court, challenging the final judgment and the sale many times. 2017, she filed a motion to vacate, raising these exact same arguments, challenging the assignment of bid that was filed 5 years ago in 2017. 2019, she filed more motions to vacate, raising the same defenses and issues. 2020, several motions to vacate, raising the same arguments. And then the current one in 2021. She also filed a detailed objection to the sale based on these same arguments. That was in November of 2018. That was a timely objection within 10 days of the sale occurring under Florida statute 45031. But this is not an appeal from an order denying an objection to a foreclosure sale. This is an appeal from an order denying a motion to vacate a final judgment that was entered more than 5 years ago. She's appealed some of those other post-judgment motions. Most recently and most notably, her 2020 motions to vacate were appealed to this court in case 2D 201452. She was represented by the same attorney, Mr. Garfield, and she filed the same briefs, making the same arguments. This court affirmed the order denying those 2020 motions to vacate. She once again moved for rehearing en banc and certification. This court denied that motion just last year. Then she appealed once again her 2021 motion to vacate, and that's where we are now. The trial court, in denying the motion, stated, quote, "Defendant's serial motion is untimely, facially insufficient to provide a basis for vacating the final judgment of foreclosure, and improperly seeks to relitigate issues and defenses that have been conclusively and finally adjudicated," unquote. I don't think she could have captured it any better, and it would have been legal error to hold yet another evidentiary hearing on these. There was many hearings on, it was a full trial on the merits of these issues, and then there were many post-judgment hearings on these same exact defenses and arguments. And she appealed many of those, and they were affirmed. She's also filed several lawsuits on these same grounds, mostly in federal court, but at least one at wrongful foreclosure case in state court. And just last year, this court affirmed the orders of dismissal of her wrongful foreclosure case against us. That was in 2D 193949 and 2D 200574. Those were on the same arguments, same grounds. And so this appeal is the most recent motion to vacate on the same grounds, the same issues, the same defenses. And for what it's worth, the property has been resold multiple times to new third-party bona fide purchasers who are not here, not joined. And so what's clear is that the two parties to this appeal, the appellant and the appellee, have not had any interest whatsoever in this property for several years. And as Mr. Garfield explained, this entire appeal is based on a routine assignment of bid filed 5 years ago in 2017, which was after the judgment was entered in 2016 and well before the foreclosure sale occurred in late 2018, that she timely challenged through an objection to sale in 2018. She didn't appeal that particular order denying the objection, but she appealed several other orders denying motions to vacate on these same grounds. And so, we've detailed the arguments in our briefs. Ultimately, the trial court didn't have the legal authority to entertain the successive post-judgment motion. The grounds either were raised or could have been raised in her prior motions to vacate. In this case, they were raised in her prior motions. The underlying arguments regarding lack of standing, lack of capacity, those do not provide grounds for vacating a final judgment under Rule 1.540. Again, there's no intelligible argument here that the final judgment was void or that it was obtained through any extrinsic fraud that would have prevented her from participating in the case or challenging these issues. And instead, she did participate in the case actively and did challenge based on these same issues. So there was no, for those same reasons, it was untimely as well. And there was no basis for an evidentiary hearing. It was a facially insufficient motion. It was a serial successive motion. So unless the court has any concerns, just with respect to the assignment, Your Honor is right. It doesn't matter. This is not an appeal from an objection to a foreclosure sale. An order denying an objection to a foreclosure sale, it's an appeal from an order denying a motion to vacate. I think what Mr. Garfield is getting at is, well, the appellee is not the real owner because the certificate holders maybe are the real owner and not the trust itself, but the certificate holders are really the real owner of the loan. And that's what we could have shown. Well, it didn't matter in 2016 at trial who the owner was. And it certainly doesn't matter now who the owner was. We foreclosed based on our status as the holder of the original note endorsed in blank. Ownership's never been relevant. And it would have been improper for the court to just hold a hearing on these issues about whether, an assignment is valid. In other words, even if Mr. Garfield had established this assignment was completely invalid, none of that would have provided a basis to vacate the judgment. If he had proven that the appellee is not the owner, that also would have not provided a basis to vacate the judgment. None of this does matter. And so just procedurally, this is a Rule 1.540 motion. There's no basis under Rule 1.540 to vacate the judgment. And so we'd ask that the court affirm the order denying the motion. Thank you.
Thank you, counsel. Pardon me. Mr. Garfield, your 3 minutes remain.
Thank you, Judge. The motion was a 1.540 motion, and if there was no claim to begin with in this case, then there is obvious fraud. If the named claimant, even if it existed, possessed ownership of the underlying obligation as required by Florida Statute 679.203, then unless they owned that, they had no claim. And by putting forth evidence saying that they did have a claim, that would be fraud. This comment that ownership is not relevant is incomprehensible to me. Florida Statute 679.203 makes it very clear that in order to prosecute a claim for foreclosure, you must have paid value for the underlying obligation. That's ownership. He makes reference to the fact that the subsequent sales are to people who are not present in this court. That's true. Neither are the registered holders of certificates who are not described, identified in any manner. There is no way to identify them. The motions that were filed, serial motions, by the way, Mr. Cohn is entirely correct in his chronology of the events. We concede that. The motion, but his characterization is inaccurate. The motions that were filed pro se were in effect, well, not in effect, they actually did object to the sale. And to say that Kiliani is asserting that the certificate holders were owners is the opposite of what Kiliani is saying. What Kiliani is saying is that neither the trust nor the certificate holders had established on the record any basis on which they could claim ownership of the debt and that the assignment of the bid created a necessary issue for litigation to be allowed in discovery and at an evidentiary hearing to establish whether or not there had been jurisdiction in the first place because of the failure to recite consideration and the failure to name an assignee. With that, I conclude.
Thank you, counsel. That will conclude our agenda for today. On behalf of the court, we wish you all Godspeed and please stay healthy. And that will conclude our oral argument session today. And judges, I'll be doing what I need to do to establish our conference ASAP.